Hello, welcome to OSH 390, Workers' Compensation here at Eastern Kentucky University. My name is Barry Spurlock, and I'm the professor who's going to lead you through these 8 weeks of instruction. Before we get going talking about the introductory concepts of workers' comp and some of the foundational principles, I wanted to share with you my story, and hopefully that will help explain why I think, and I think a lot of the other faculty at our university would agree, workers' comp is a very important class for our students, because inevitably you're going to encounter this as a safety professional, whether it's peripherally and investigating an injury or dealing with the hiring process or interacting with human resources, or whether you're in charge of managing the function yourself. Workers' comp is an imperative topic for you to cover. I remember my first internship, which happened to be with a federal prison. And during this internship, I watched the safety department manage and interact with both workers who were injured on the job and also inmates. Yes, even inmates got workers' compensation in federal prison. And then later on, I did another internship at a rubber manufacturing facility. Once again, watched the safety manager spend a lot of time dealing with workers' compensation issues and managing the process. Then later on, after graduation, and I was working as a safety manager both in the steel and in the food industries, I now was in charge of managing workers' comp, 2 companies that were self-insured for workers' compensation, and it meant a lot. It was a big part of my job to manage workers' compensation. And then later on, I worked for almost a decade for a workers' comp insurance company, but now I'm working on the loss control side. I was the safety consultant who worked for the workers' comp insurance company. So I got to see a different perspective of it. And when you think about the fact that 20 to 30% of the folks with degrees in occupational safety actually work for workers' comp insurance companies, it further bolsters that this is a very important class. So if you haven't encountered workers' comp yet and you're pursuing this degree, count on it, you will. If you've been working this field not very long at all, you probably will agree with me too that workers' comp is a pretty important topic. So let's go ahead and get started in discussing this course. And first of all, I want to share with you a process or our approach to this class. This is really more of a survey class where we're going to explore a lot of different topics as it relates to workers' comp to hopefully help prepare you and make you well-rounded in this aspect. I refer to this as a claims to coverage approach. We're going to kind of begin with the end in mind. Unfortunately, it's the end that we hope doesn't happen. We hope workers aren't injured and that there's not workers' comp claims. But inevitably, somewhere along the line, there's probably going to be workers' comp claims you're going to interact with. But it's important for you to understand how that process works. And then I think when we talk about controlling loss, preventing loss, and then how companies buy workers' comp insurance coverage and how that works, I think it will make the best sense if we begin talking about the claims. Almost begin with the end in mind, albeit an end we hope we don't have to deal with. In the claims section, we're going to talk about injured worker benefits. We're going to give a survey of those, explain what the various benefits are that injured workers receive through workers' compensation, talk about the claims process. We're actually going to talk about those things here in week 1. But we're also going to talk about the claims and disputes and the litigation, and particularly the issue of compensability. When is it that a workers' comp claim is compensable? Meaning, when is it that a worker makes a claim for injuries and they get workers' comp benefits for it? Really, it's compensability. That's what we're talking about there. When is a worker legally entitled to these benefits? It's imperative for you to understand compensability, because in understanding it, you also understand the no-fault exclusive remedy nature of workers' comp. Workers' comp is going to be quite an adjustment for what you're used to thinking about when we talk about litigation and the law and liability and fault. Workers' comp is going to take all that and kind of turn it upside down. So we're going to talk about the claims. Once you understand what's at stake in workers' compensation, I think the loss control measures will make more sense. And when we move to that phase of the class, we're talking about what measures can an employer put in place? What measures can they take to control loss, workers' comp loss internally? But we're also going to talk about the measures that an insurance carrier can take, both internally to the insurance company, but externally in helping the companies they insure prevent and control and mitigate loss. In this segment of the course, we're also going to talk about analyzing workers' compensation loss data. Workers' compensation loss data controls a lot of actions within a workers' comp insurance company, and we can make arguments about whether that data is extremely reliable when we talk about safety performance and whether it's not. However, we're going to analyze that and let you see how they approach that. But then we're also going to talk about the role that loss control professionals play. These are the safety folks who work for the insurance company. Like I said, I did that for 10 years, a wonderful career. And a lot of you are going to work in that if you're not working there already. We want you to be prepared for that role. And then finally, we're going to talk about workers' compensation coverage. This is really where we're going to talk about the insurance side of this. We're going to talk about what are the coverage options. How does a company secure workers' comp coverage? Well, sometimes they might be self-insured if they have enough assets and they can do what that particular state requires to be self-insured. They might buy workers' compensation coverage through some high-risk fund, some fund that's created for that particular industry, or they may have to be in a monopolistic state, and that means they have no choice in where they get it. They get it through a state-ran fund. An example of this is the state of Ohio. Or, and as in most cases, they go secure workers' compensation coverage on the private market or the competitive market, we're going to call it. And this is just like the company buying workers' comp coverage, like you might buy auto insurance or you might be homeowners insurance. A little more complicated, a little bit different, but generally speaking, they're just buying workers' comp and transferring risk. So that's the approach to this course. We're going to spend a lot of time talking about claims. We want you to understand compensability. But once you understand that, you understand what's at stake, I think that the loss control measures, what you need to do to control that loss, and certainly the coverage, and what that means will make a whole lot more sense. And then we're going to end up, like I said, talking about the insurance side of it. We're not going to make you underwriters, but we certainly want to make you able to have a conversation with insurance underwriters and brokers and people you might encounter when they're talking about things like experience rating and the underwriting process. So that's the approach to the course. That's how this course is going to progress. Before we dive in and really get into some nuts and bolts, I want to give you a little bit of a backdrop of how we came about having workers' comp and what's its purpose. I think when you understand the purpose of workers' comp, it also helps you understand claims, which, as the previous slide showed, also helps you understand the other stuff. Realize this, workers' comp has not always existed in the United States. There was a time, and it really wasn't that long ago when you look at the progression of time and man, that there was no workers' comp, not in the United States. And at that time, we were largely an agrarian society. Most people were farmers or blacksmiths, or there certainly were entrepreneurs of some sort. They were a lot more self-sufficient. We didn't have factories and large corporations where people were employed. They were largely dependent upon themselves. But prior to, and certainly during, and really certainly right after the Industrial Revolution, we saw a shift in the American workforce. We became more industrialized, and more folks were employed by companies and entities and other people and not themselves, which created a really unique situation when the employees were injured on the job. Now, obviously, if they worked for themselves, there was very limited, if any, legal recourse to take care of them once they're injured and disabled. However, when they're working for someone else who's benefiting from their labor, it created a different set of questions as to who would be liable and who's going to take care of this person. Now, even before workers' comp, so pre-workers' comp injury outcomes, there were two things, and these are the first bullet occurred even when we were an agrarian society. The injured worker became a burden upon society. You have a worker who's been hurt, and now they cannot provide for their families. And this is a fact. This is not a personal position here, but in America, before the Industrial Revolution, during, and certainly even thereafter, we had larger families. We usually had one breadwinner in the family, and it was usually male, and they provided for the family. And what happened when that breadwinner, that person who earned the wages for the family, is now disabled and can't provide for the family? Well, many times the extended family, churches, charitable organizations, and other similar entities would then take it upon themselves to now care for this family who is either close to being destitute or would be destitute were it not for the help that they're getting. So society kind of picked up the slack there. Now, that same thing was still a problem even after we became an industrialized society and during and after the Industrial Revolution. A worker could get hurt in a factory, and they had two choices now. Before, when they worked for themselves, they really didn't have anybody to sue. But now they've got somebody to sue, their employer. So they would sue their employer through a tort action, what we call common law causes of action. One of them, and certainly the most prominent one and most common one, is negligence. They would sue the employer for negligence. And they would, through this lawsuit, they would try to recover money, damages for the injury they sustained while working for that company. But if they were unsuccessful with that, they were going to be a burden on society. Or if they chose not to sue the employer, they're a burden on society. Now, I'm sure you've already piecing this together in your head, but if not, you can see that neither of these were probably good outcomes for us, and it became a problem here in the American society. And said, we've got to do something to deal with these work-related injuries. Now, I'm going to shift from that work-related term here pretty soon and start calling it compensable, because that's the term we use in workers' comp, not work-related. So, before workers' comp, two outcomes. Injured workers a burden on society, or they sue their employer. And this is a traditional lawsuit. So, if they sued their employer for negligence, pre-workers' comp, keep a few things in mind. That this is a tort action. It's a common law lawsuit that's being filed in a court, such as a circuit court, district court. Those are the various courts, the names for the courts. A tort's basically a civil wrong. It's either something somebody does or something they don't do. They fail to act, or an omission that causes harm to another party, for which legally the courts or through the legislatures, they said there is a way to recover for this type of wrong. And there's various types of these. Negligence, obviously, is one type of tort. Other types of torts include defamation, false imprisonment, and then there are things like intentional torts, like assault and battery. So there's various types of torts, but certainly the one that was involved in workers' comp, I call it a cause of action. Cause of action is basically the court saying you can sue somebody for this, like suing somebody because they hurt your feelings. That's not a cause of action. You can't go down and file a suit for hurt feelings. Now, you might go down and file a suit for what we call intentional infliction of emotional distress, which has its own elements. That's been recognized by courts as a common law cause of action or tort. Now, when we talk about somebody getting physically hurt here at work and work-related injuries, the tort in particular is negligence. Now, there are different forms of negligence, gross negligence, and it depends on the state. But the common law tort that employers were sued for by employees when they were injured was negligence. It's the same cause of action that you see folks getting sued for in car accidents or maybe slip and fall cases in a retail store. It's the same tort. They sued their employer just like you might sue someone in a car accident or for a slip and fall injury. Negligence. Negligence was the tort that was utilized before we had workers' comp, when injured workers sued their employers. Now, to sue someone for negligence, there are elements of what we call a prima facie case. They have to prove all of these things in order to be successful in the suit for negligence. The first element of negligence is a duty. They would have to show that the employer owed them a duty. This injured worker, when I say they, I mean injured workers, would have to show the employer owed a duty. Namely, that duty would be to do something to keep them from getting hurt, whether it be some measure they would take or something they would refrain from doing or causing the employee to do. They would have to have a duty. And then they would have to show the employer breached that duty or failed to fulfill their duty. And basically, this is showing that what would a reasonable employer making this kind of product or in these circumstances do in this situation? And that became somewhat a little more contentious part than the duty. But then they would also have to show causation. Now, there's two types of cause. One cause is cause in fact, meaning were it not for these facts, the event wouldn't have occurred. And there's proximate cause, or legal cause, as some would refer to it, meaning will the court extend liability here? Basically saying, were it not for the condition of this piece of equipment or this work process, the injury would not have occurred. Proximate cause, will the court allow this liability to be extended to that far? And then the final element of negligence they would have to prove are damages. Now, there are different types of damages. Particularly in negligence, we'll see economic and non-economic damages. Economic damages are usually the ones we can put a fairly precise calculation on as to how much it cost. For example, if I was in a car accident and someone damaged or totaled my car and I knew what its value was, and I'm suing them for that amount to replace my car, that would be an example of an economic damage. In the workers' comp context, if we were talking about lost wages, and we know an employee makes X amount of wage per week, and they were off work for 37 weeks, we could come up with a pretty precise calculation as to what that injured worker's damages were for the lost wages. Those are economic damages. We could extend that to medical expenses too. However, there are things like non-economic damages in negligence that you could also recover. The one you probably are familiar with, and it's certainly probably the most common when we talk about injuries and negligence, is pain and suffering. So you might get your losses recovered for your lost wages and your medical expense, but you might also get some money for pain and suffering on there, the non-economic damages. So also wanted to point out there that there are other defenses, common law negligence defenses to torts. Those include assumption of the risk, an act of God, fellow servant doctrine. Just to touch on those briefly, obviously not as prevalent or as predominant as contributory negligence, but an assumption of the risk would mean the employee is not entitled to anything legally because they assumed a certain risk in engaging in that particular employment. Now, if I give you a modern day example of this, I remember the first time my wife and I went to Chicago together. We're downtown. We decided to ride the L, seeing the sights. We decided to ride it at 5 p.m. on a weekday. Well, that probably wasn't the best idea as sightseers. And I remember trying to get on the L to crowded station. I went on first, and she comes behind me. Unfortunately, lots of people converged and really almost they pinched us off because she was kind of holding onto my back. Of course, both of us are from the Appalachian, southeastern Kentucky. We'd never been in a big city like that before. And she was not going to lose me because there were no cell phones or anything like that she could say, hey, wait on me at the next station. So she was bound and determined to get on that car. She just kind of pushed her way in there, and people are elbowing and bumping one another. And what if somebody were to sue her because she bumped into them getting on there and sued her for civil assault? Civil battery in that case. Well, it would be a defense in that case because the deal is when you ride a public transportation like a subway or the L in Chicago in rush hour, you assume certain risk. That you're probably going to bump shoulders with people. You assume that risk. Or imagine if a football player was injured after being tackled and he wanted to sue the other player for tackling him, just ordinary tackling him. The defense of that is going to be you assume the risk. You signed up to play football. It's a physical sport. Those kind of things are going to happen. You knew that. So that's what assumption of the risk was. And you could see what would happen if an employer raised assumption of the risk. You knew these risks when you decided you wanted to work in a foundry or automobile manufacturing facility or some construction company. If the employer is able to raise that, the employee got nothing. And there's act of God. What if the employee was out working in a field and was struck by lightning? And the employer asked him to be out there. Well, a defense to torts, sometimes an act of God. That it wasn't a fault of the employer, it's just an act of God. If they were able to raise that defense, then the employee got nothing. Fellow servant doctrine is another common thing, the common defense that was used, saying, hey, we're in this together. And it dealt with other areas of liability, not just, the injured worker and the employer's liability for that, but would the employer be liable if one of their employees did something to another party? So fellow servant doctrine had implications beyond just a worker and the employer. It was the worker's actions. Well, if a worker undertook a certain task or something, even though it was in the interest of the employer, the employer didn't tell them to do it just that way, would they say, I'm not liable for the actions of my servant, meaning they being the employer. If they were able to successfully raise that, the employee got nothing. So you can see how these common law negligence tort defenses came to play here. If the employer was able to raise them, even contributory negligence, the employee got nothing. And as I said, contributory negligence was no doubt, the predominant defense. They just had to show that the employee was also at fault here and had some blame. And as I pointed out here, that's been replaced even in tort law by what we call comparative fault. So that now when a plaintiff sues a defendant for negligence, even though the plaintiff may have had some role in it, maybe they were 10% liable or 10% to blame, putting in very simple terms, and they get $100,000, they'll only get $90,000 because 10% of the fault was assigned to them. Even in tort law, the contributory negligence defense has disappeared. But that didn't happen until long after workers' comp had already came about in the United States. So keep in mind, the effect of employers successfully raising these defenses to an employee's negligence lawsuit meant the employee got nothing. But if the employer was not successful in raising the defense, and the last bullet happened, the employee successfully sued the company, the employee could get their actual damages, and they might also get non-economic damages back. And it was a jury deciding this verdict. And you can imagine sometimes it might be fairly lucrative for the employee, if they can win, to sue the employer. So let's put this in a graphical perspective here to kind of show pre-workers' comp and the understanding of why we got here. We would have a work injury occur. And I'm going to get my cursor over that. The work injury occurs, one of two things happen. If the employee's disabled, can't work anymore, they're a burden on society, or they would sue the employer. If they're a burden on society and they didn't sue the employer, kind of stops there. And that's a problem. That's an undesirable outcome. However, if they sue the employer, there's one of two outcomes. The employer is going to successfully defend against the lawsuit, raise those defenses like contributory negligence, assumption of the risk, act of God, and then they would win, and then the employee gets nothing. Or the employee wins the lawsuit against the company, and it may be a very large jury verdict, which would harm business, which would in turn cause jobs to be lost. So if the employee gets no benefits, it becomes back a burden on society. However, if we lose jobs because the business has had this very large lawsuit now against it and a large judgment against it, we come back to the same thing. It was a burden on society. And they said, hey, something has to change. We have to have a system to deal with these work injuries so that employees aren't a burden on society and we take care of them. However, we also have to prevent against these windfall jury verdicts against employers that put them out of business. What are they doing in England? That's what a lot of our law came from. Workers' compensation, and that's kind of how it was born here in the United States. So we had to have some trade-offs when workers' comp came about. First trade-off was it's no fault. In workers' compensation, the employee's contribution of fault or the employer's contribution of fault is almost virtually irrelevant. Doesn't really matter that the employer was negligent or that the employee was negligent. It's no fault. This is a trade-off that primarily benefits the employee. It assures that the employee is going to be taken care of. They're not going to be a burden on society, even though they may have just been negligent in how they performed the work. And they don't have to show that the employer was negligent in how they behaved or the conducting of the business. That's the trade-off that primarily benefits the employee, protects them, even if they're at fault. Remember that contributory negligence defense. This takes it off the table. Let's not worry about that. Let's take care of the worker. However, we got to think about the employer in this as well. Here's the trade-off that primarily benefits the employer, is that it's the exclusive remedy for the injured worker and their family. Injured workers can't sue their employer under negligence when they're getting workers' comp benefits. So most state statutes will spell that out, and they'll make it very plain that workers' comp is the sole remedy for your work-related injury. Now, there's some states They have some exceptions built in here and there that allow some employers to opt out of the workers' comp system, but that exposes them to tort liability. A perfect example of this is Texas. Texas has some unique things there. Toward the end of this presentation, I'm going to reveal that workers' comp is very state specific. But for the most part, and I'm going to talk in generalities in this class, if an injured worker or someone is hurt on the job, unless there's been some extraordinary measures prior to the injury, they get workers' comp. They can't sue their employer for negligence. They are barred from that by statute. So is their family. Their loved ones barred from suing the employer or suing the agents of the employer. It's like, well, I can't sue my employer, but I'll sue my supervisor for that injury. No, that exclusive remedy protection extends to the supervisor, the agent, also the coworker. They may say it was my coworker Joe's fault that I got hurt. I can't sue my employer, but I'll sue my coworker. No, that exclusive remedy protection extends to the coworker too. And that's by statute. That means the legislature in the various states have put that in place. So keep this in mind. Workers' comp is a no-fault exclusive remedy that takes care of workers when they're hurt on the job. The workers, they don't have to prove fault. The employer is liable for the work-related, the compensable claim. Work connection is all that merely matters in establishing employer liability for the injury. That's a trade-off that benefits the employee largely. But the trade-off that benefits the employer is that the injured worker can't sue them for negligence in a traditional court and get some windfall jury verdict. Some folks have that misconception that if I get hurt at work, I'm going to cash in and I've got it made. That's not how it works. And just because there are injury lawyers who have commercials on TV saying, call us, we'll represent you for your work-related injury, that doesn't mean there's going to be this windfall verdict there. Lots of law firms like that, they've got the workers' comp down to a science, and a lot of times it's just changing names on certain pleadings, and it's a very mechanical process, and they're helping them through that process just as someone would hire a lawyer to help them get Social Security or some other benefit like that. So that kind of gives you a little bit of a background where we're at, but I want to reiterate a couple of things about workers' comp versus tort law and distinguishing those things. One of the biggest things, you got to remember this in this class, that fault is largely irrelevant. Fault is the F word. Fault is the F word. Using the F word in OSH 390 will be problematic for you. Don't use fault in your analysis of compensability in OSH 390. Don't use it when you get out there later. It's not fair to say, well, the employee didn't follow the rules, and therefore they don't deserve anything. The employer wasn't negligent. Negligence is not part of this. Fault is not part of this equation. Nor is it safe to say, well, that employer was bad. They didn't do what they're supposed to. They were clearly negligent. Therefore, they owe the injured worker money. Fault is irrelevant. Don't use fault in your analysis. Now, there are these issues with employee intentional misconduct, but that really deals with the two-pronged test of compensability. It's not really getting into fault. There we're saying the injury did not arise out of employment or did not occur or did not arise in the course of employment. It's best not to say the word occur, even though I just did it. It's did the injury arise out of employment or in the course of employment? If it's intentional misconduct, we're really making an argument that it doesn't meet the basic test of compensability, that it didn't arise out of employment. There's no causal connection there, or time, place, circumstances weren't right, an activity. So fault is not really an issue in workers' comp cases. I'm sure that provides a little bit of insight once now that you've posted discussion board responses regarding the Nina Pham case. Now, and I want to make another distinction. Dispute litigation, jurisdiction, and processes for workers' comp versus a normal civil lawsuit for negligence. Tort actions are litigated in the ordinary trial court. Examples. In Kentucky, we refer to them as circuit courts. Some states and federally would refer to it as district courts, although you're rarely going to see a workers' comp case in a federal court because workers' comp is largely a state issue. Now, if you're a federal employee or there's federal contracts involved or maritime stuff, sometimes those things end up there, but that's very odd. It's really how does the state set up its court systems. Like I said, in Kentucky, circuit courts is where we deal with negligent lawsuits for the most part that are over a certain amount. Some states call it a court of common pleas. In these kind of courts, this is what you've seen on TV. This is what you normally think of when you think of a trial and a lawsuit, as a judge and a jury. That's the typical American courtroom perception. But that's for tort and negligence. Now that we have workers' comp, we're in a different tribunal. We're in a different forum for settling these disputes because they're administrative hearings. It's the Workers' Comp Claims Board or the Industrial Commission or some other board, and it is an administrative law judge that oversees the whole thing. He is both the trier of fact and the trier of law, meaning he is both judge and jury. In a traditional court, the jury is who weighs out the facts and decides whether they're going to believe them or not, or the weight of the evidence. The judge decides issues of law. Was this evidence admissible or not? Or could this process proceed the way it is, and overseeing the legal aspects of the case? But in workers' comp, the administrative law judge is who's overseeing the whole process. It's not the grandiose courtroom and the theatrics that you might see in watching TV. It's usually these hearings, at least at the start, and if you want to equate it to a trial, that's appropriate. But the workers' comp hearings is usually an administrative law judge, a court reporter, an attorney for the injured worker, an attorney for the worker, the employer, and maybe a witness. And they're in a conference room. And that's where it takes place. A lot of folks think workers' comp is litigated through some courtroom process. And that's just not how it works. Now, I'm hoping that my image has faded a little bit in the back, but if not, you'll be able to download these slides and see this. I put this together to help you understand kind of the flow, if you will, of the workers' compensation adjudication process. So workers' comp adjudication with the trial, the hearing. How do we adjudicate a workers' comp claim from start all the way up to the end of the road for this? So the first thing that happens is an employee will report an injury. We know that. Once the employee has reported an injury, the employer should record that, investigate it, and then file a claim with their workers' comp carrier insurance company. Or if they're self-insured, many times they'll have what's called a third-party administrator. And a lot of states refer to this first report of injury as an IA-1. That is kind of a standard form used in a lot of different states, but some states have their own version of this. Once that is filed with the insurance company, the insurance carrier, and if I say carrier, I mean the insurance company, will evaluate that claim. And then at that point, they'll usually assign it to an adjuster. If it appears it's just a medical-only claim, the employee got 4 stitches, they're not going to miss a lot of work time, then they might go to a medical-only adjuster. But if it appears it's a more severe claim, the worker actually might miss some time, then they'll assign it to a lost time adjuster, who's usually more experienced in handling a little more complex claim. Now, the insurance company makes a decision at that time. They either accept the claim saying, yeah, it's compensable, we're going to pay it, or they deny it. They say, hey, it's not compensable, we're not liable for this claim, or the employer who we're a third-party administrator for is not liable for this claim. Or they might accept the claim, waiting to see more evidence that comes in. Now, obviously, if they accept the claim as being compensable, they will pay benefits to the claimant. They'll pay the medical bills. They might pay their the benefits for lost time from work. We're going to talk about what that means specifically here in just a moment. Let me get this cursor to behave. And they just pay that, and the claimant is okay with what they're getting. They accept those benefits. The claim resolves, and all is happy. However, and this is usually how it usually occurs when there's an employee it's clearly a compensable claim, but there's a dispute over how much money the worker should get. There's a dispute over how much money they should get, as far as maybe permanent partial disability. Or if there was a denial of the claim and now the injured worker wants to dispute the denial of the claim, they're going to then take that to workers' comp court, if you will. I'm just using a very simple term to explain it. But they're going to go to court. Somebody's going to file an action so that this workers' comp administrative tribunal will look at this. So in Kentucky, it's called an application for the resolution of claim. It is akin to filing a complaint in a civil lawsuit. That means, hey, we have a dispute. We need the courts to determine this. We need a judge to sit and help, or not help, but make a decision on this. Once that happens, an administrative law judge is assigned. You'll frequently hear me call it an ALJ, most people. Administrative law judge will be assigned. And then this will begin a process just like a civil lawsuit, except it's in a different kind of environment, a different forum. We have discovery, and this is where medical records are requested by the workers' comp insurance company, the employer's TPA. And they might even take depositions during this. They might get statements from people. Information and evidence from the employer might be obtained here. Prior medical records, all that stuff. That's the discovery, just like in a civil lawsuit. Then, which leads up, and there might be various motions and other things that occur in between this. We would have a hearing or a trial, if you will, before the ALJ. Now, at the end of this trial, if one of the parties say, hey, there was an error here in this law, then they would appeal, and that normally goes to a full commission or full board. Now, sometimes it might bypass that depending upon the state you're in, but a lot of them will have an appeal process before it heads to an appellate court of the states. They might appeal to a state court of appeals. And then if there's still an appeal to be taken after that, it usually goes to a state Supreme Court. Now, throughout all this process down here at the bottom, from the time discovery is going on, before the hearing, all that, we could have a settlement in this case. They could settle it, and most of them do, just like civil litigation. Now, you'll notice that I've put the appeal to the state Supreme Court. That's kind of the end of the road. The reason being, and the reason there's no U.S. Supreme Court here, is because this is a state law issue. For the most part, 99% of the claims are going to be confined to a state. There's no federal right here necessarily involved. Therefore, it's not going to end up in a federal court. So I hope that gives you a good view of how a workers' comp claim progresses through the process, that it's not this jury and the theatrics you might see on TV with a court case before there. A lot of similarities, but there's a lot of differences in this too. Here's the thing, too, I want you to keep in mind. You're going to be reading cases in the text. These are actual workers' comp cases. The cases you're reading in the book, largely, 95% of them have went through this entire process that you see here. There had to be, the worker got hurt, they reported it, it was given to an insurance carrier. The lawsuit will have the employer's name on it, but this is an insurance company that's paying for the defense and seeing the defense of the employer through here. It's went through an administrative hearing process. It's went through an appeal to a commission or a board. It went through the state appellate court and the Supreme Court. Now, some of the cases you read in the book, they went to the state court of appeals. But a lot of them have been before a Supreme Court. So keep that in mind. This is a backdrop for reading the cases in this class, that they went through this entire process that you see before they ended up in the book that you're reading. Now let's talk about some of the common workers' comp benefits. First of all, and this is an obvious one, is medical benefits, frequently paid 100%, but that's subject to state jurisdiction fee schedule. Certain states only allow certain amount of charges for certain medical services and benefits. For example, in some states they'll have a fee schedule that says an MRI. The fee schedule for an MRI on this body part is X amount of dollars, and that's all that medical provider is going to get paid for that. So medical benefits are paid at 100%, subject to that fee schedule. The employee is not going to be liable for paying any of the medical, although it frequently happens. And when I manage workers' comp in industry, I would frequently have injured workers come in with a medical bill where a medical provider is trying to charge them the difference between what they're charging for a service and what the state fee schedule will allow. And that's usually just because the billing service and the medical provider, they don't understand the nature of workers' comp. We would often settle that, remind them you can only charge this much because it's a workers' comp claim. But the employee is not responsible for the medical benefits. Now there's next benefit, temporary total disability. This is what the workers get paid for lost wages when they're off work and can't work at all, but they are convalescing and hopefully coming back to work. So this total disability is only temporary. This is often paid at 66 2/3% of the average weekly wage. Now, it's subject to a waiting day period. In the state of Kentucky, it is 7 days. An employee has to be off 7 days before they're entitled to get any TTD. then it's temporary total disability, and then it starts paying 66 2/3% starting at day 8 of the TTD period. Now, once the worker has missed 15 days, it can come back and get the first 7, but they would have to do that. A lot of states have it like that. Kentucky's not unusual in that respect. However, there are some states that have a much shorter waiting period, and you'd have to look at your jurisdiction to figure that out, and that's also part of the research paper in this class. Another benefit's permanent partial disability. This means the employee was injured at work, compensable claim. They have now recovered to the point that is as good as they're going to get. That's often referred to as MMI, maximum medical improvement. Once they reach maximum medical improvement, it's as good as they're going to get. We're going to determine, do they have any permanent partial disability rating? Meaning they can come back to work, but they might not, they're not 100%, they're not themselves. How much benefits are they going to be entitled to? Well, we would look and see what percent of a whole body equivalent are they now disabled. For example, if I were to lose function of my hand, I might have 100% disability in my hand, but what does that equate to me as a whole person? Or AMA guidelines that the doctors look at, and they complete evidence to help make a calculation to whole person impairment, and then they frequently look at how much money the person made, and they might look at other factors to determine what do they get for this disability. And that's what we call permanent partial disability. Then there's permanent total disability. This means the worker's hurt, injured, cannot ever return to work, period. Then we look at things like age and earnings and education and what that means. And another, again, it's very formulaic. Formulas and some of the what's allowed and not allowed varies from state to state. But that's another type of benefit that workers get. It's permanent total disability. Then there's rehabilitation or vocational rehabilitation benefits. Again, this varies widely from state to state as to what they allow, what they don't allow. But in some states, it's not going to be much. Other states, it's very generous to the injured worker. However, it is a common type of benefit there. And then obviously death benefits. We hope we never have to deal with that. We don't have an occupational fatality, but if we do, there are death benefits. Obviously, these are going to be payable to the injured worker's spouse, family, dependents. The worker themselves, they're not allowed to receive those benefits. And by the way, if you know something about tort law and law, you know you've heard of something called a wrongful death suit. Keep in mind that wrongful death suits are brought by the surviving spouse, family, dependents, those folks. However, they're barred from doing that in workers' compensation because, again, workers' comp is the exclusive remedy. So they would get those benefits. Now, whether it's payable to the injured or the dead worker's estate, that varies from state to state, how much and provisions on that. Now, there are other workers' comp benefits. Another one sometimes is temporary partial disability. And it might be working some schedule. That varies from state to state, and I only listed the common ones here because these are pretty much going to occur in most all states. So those are the common benefits. This is what is at stake now that we have workers' comp. This is what the employee is going to get via workers' comp, and they're not going to be able to sue their employer and get non-economic damages like pain and suffering. And if you haven't figured this out, if you think about this, folks don't get rich off of workers' comp. Now, there's a concept called indemnity, and frequently workers' comp carriers will have a column in a loss run that says indemnity or indemnification. The term indemnify really means to make someone whole. Workers' comp really doesn't do that. It doesn't put them back in a position they were before injury. Workers' comp is really designed to keep people from being a burden on society and get them through, not to make them rich, not necessarily to make them whole. So keep that in mind. Workers' comp is very state specific. As we go through this course, you need to keep that in mind. It is very state specific. There are some states who are notoriously more employer friendly, while there are other states that are notoriously more employee friendly. A claim that's compensable in one state might not be compensable in another because the way that state's laws have shaped the definition of compensability. So the claims process, the benefits, what is a compensable injury in one state versus another, that varies a lot. But there's a lot of other ways that workers' comp varies from state to state too. Many respects. One rates how much a company pays for workers' comp in one state versus another. a lot of that's dependent upon how the state treats compensability. But when I worked in workers' comp, I know there were certain states that the workers' comp insurance company I worked for, we just didn't do business in those states, period. And there was in some states, the rates that we charge for the same coverage in that state might be cheaper than another one based on that. How they classify employees during the underwriting process and what options are available, that varies from state to state. The requirements for renewing an employer's policy or canceling a employer's workers' comp policy, and what kind of notice they have to give those employers, the insurance companies have to give the employers, varies from state to state. Benefits, state to state, and then obviously the adjudication and how we resolve a claim, and there's other aspects. But you need to keep that in mind. Just because you've heard a story of what happened in one state, and then you hear another story, it sounds similar in another state, but two different outcomes, that's because there's two different states' laws that are at play there, and they may have a different outcome. So looking ahead to week 2, this is going to become the heart of the claims module of this course, is understanding what it takes for a workers' comp claim to be compensable. To be compensable, it must have arisen out of the course of employment and in the course of employment. Now, I'm going to show you a couple of state statutes where it looks like that and is an or. But if you were to look at how those states apply the law, it's really more of an and. Or maybe they only have one statement. But the analysis ends up being very similar to us saying this. And in the most states, it's arising out of and in the course of employment. What we're going to do is we're going to look at cases, we're going to look at risk doctrines that demonstrate the concept of arising out of and in the course of employment. So we're looking ahead to week 2, looking forward to that. I hope this has gave you some insight on workers' comp and kind of built this foundation and let you understand the no-fault exclusive remedy nature of workers' comp, that it's work connection that determines employer liability and not fault. And keep in mind, fault, the word fault is the F word in OSH 390. We'll look at compensability next week, and that'll be really important. Thank you.